Good day everyone, my name is Kent Jose Petezer de la Peña from St. Francis Xavier College Criminology. I'm third year from Section Charlie. For this video, I'm going to read Article 14 and 15 from Criminal Law Book 1. Article 14, Aggravating Circumstances. The following are aggravating circumstances. Number 1, that advantage be taken by the offender of his public positions. There's are requisites. The offender is a public officer. The commission of the crime would not have been possible with the powers, resources, and influence of the office he holds. Essential public officer use in the influence, prestige, or ascendancy which his office gives him as the means by which he realizes his purpose. Failure in official in tantamount to abusing of office. Wearing of uniform is immaterial. What matters is the proof that he indeed took advantage of his positions. Number 2, that the crime be committed in consent of or with insult to the public authorities. There's a requisite. The offender knows that a public authority is present. The public authority is engaged in the exercise of his functions. The public authority is not the victim of the crime. The public authority is presence did not prevent the criminal act. Example, Juan and Pedro are quarreling in the municipal mayor upon passing by attempts to stop them, notwithstanding the intervention in the presence of the mayor. Juan and Pedro continues to quarrel until Juan succeeds in killing Pedro's. Persons in authority, public authority who directly vested with jurisdictions has the power to govern and execute the laws. Examples of persons in authority: governor, mayor, barangay captain, councilor, government agents, chief of police. Rule not applicable when committed in the presence of a mere agents. Agents subordinate public officer charged with the maintenance of public orders and protection and security of life and property. Example, Barrio Vice Lieutenant, Barrio Councilman. Number 3, that the act be committed 1. With insult or in disregard of the respect due to the offended party on account of his A rank, B age, C 6, or number 2 is that it meant committed in the dwelling of the offended party if the latter has not given provocations. Circumstances: rank, age, sex may be taken into account only in crimes against persons or honor. It cannot be invoked in crimes against property. Rank refers to a high social position or standing by which to determine pay and emolument in any scale of comparison within a positions. Age, the circumstances of lack of respect due to age applies in case where the victim is of tender age as well as of old age. 6 refers to the female sex, not to the male sex, not applicable when the offender act with passions and vocations. Number 2, there is exists a relationship between the offender and the victim, but in case of divorce, decrease, where there is a direct bearing on their child, it is applicable. Number 3, the conditions of being a woman is indispensable in the commission of the crime. Example, parricide, rape, abductions. Requisites of this regard to rank, age, or sex. Crimes must be against the victim persons or his honor. There is deliberate intent to offend or insult the respect due to the victim's rank, age, or sex. Disregard to rank, age, or sex is absurd by the treachery or abuse of strength. Dwelling must be a building or structure exclusively used for rest and comfort combinations. House and store and included. Number 1 is may be temporary as in the case of guests in a house or bed spacers. Number 2 is basis for his the sanctity of privacy the laws accords to human abode. Dwelling included dependencies, the foot of the staircase in the enclosure under the house. Elements of the aggravating circumstances of dwelling. Number 1 is crime occurred in the dwelling of the victim. Number 2 is no provocations on the part of the victim. Requisites for provocations almost concur. Number one is given by the owner of the dwelling. Number two is sufficient. Number three, immediate to the commissions of the crime. When dwelling may not be considered, when it may be considered. Although the offender fired the shot from outside the house as long as his victim was inside. Even if the killing took place outside the dwelling, so long as the commissions begin inside the dwelling when adultery is committed in the dwelling of the husband, even if it's also the dwelling of the wife, it is still aggravating because she and her paramour committed a grave offense to the head of the spouse. In robbery, with violence against persons, robbery with homicide, abductions, or illegally detentions, if the offended party has given the provocations, when it may not be considered, the victim is outside his/her dwelling. Of, if offended party are not occupants of the said dwelling. If the both offender and the offended party are occupants of the same dwelling, in robbery with the force upon things, it is inherent. Number 4, that the act be committed with abuse of confidence or abuse ungratefulness. Requisite of abuse of confidence. Offended party has trusted the offender. B. Offended abuse such trust. C. Abuse of confidence facilitated to the commission of the crime. Requisites of obvious ungratefulness. A. Ungratefulness must be obvious. That is, there must be something which the offended should owe the victim a debt of gratitude for. Note: robbery or theft committed by a visitor in the house of the offended party is aggravated by obvious ungratefulness. Example: a jealous lover, already determined to kill his sweetheart, invited her for ride, and during that ride he stabbed her. Abuse of confidence inherent in malversations, qualified theft, estafa by conversions, misappropriations, qualified seductions. Number 5. That the crime be committed in the palace of the chief executive or his presence, or when the public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. Requirements of the aggravating circumstances of public office. A polling precinct is a public office during election day. Nature of public office should be taken into account like a police station, which is on duty 24 hours a day. Place of commissions of felonies. If it's Malacanang Palace or a church, is aggravating regardless of whether state or official functions are being held. As regards other places where the public authorities are engaged in the discharge of their duties, there must be some performance of public functions. The offender must have intention to commit a crime when he entered the palace. Requisites for aggravating circumstances from place of worship. Crime occurred in the public office. Public authorities are actually performing their public duties. The crime occurred in a palace dedicated to the worship of God, regardless of religions. Offender must have decided to commit the crime when he entered the place of worship. When paragraph 2 and 5 of Article 14 are applicable, committed in the presence of chief executive in the presidential palace or a place of worship. Public authorities are performing of their duties when the crime is committed. When crime is committed in the public office, the officer must be performing his duties except in the presidential palace. Public authority may be the offended party. Committed in the containment of public authority, same outside the officers still performing duty, public authority is not the offended party. Number 6A, that the crime be committed in the night time or in a uninhabited place by a band whenever such a circumstances may facilitate the commissions of the offense. Nighttime uninhabited place or by a bang aggravating when impunity means to prevent the accused being recognized or to secure himself against detections or punishment. Nightmare be- Nighttime begins at the end of dusk and ending at dawn, from sunset to sunrise. Uninhabited place, one where there are no house at all, a place at a considerable distance from town, where the houses are scattered at a great distance from each others. It's facilitated the commissions of the crime, number one. Number two, especially such by the offender to ensure the commissions of the crime or the purpose of impunity. Number three, when the offenders took the advantage thereof, the purpose of impunity. Number four, commissions of the crime must have begun and accomplished at night time. Number one is commission of the crime must begin and accomplished in the night time. Number two, when the place of the crime is illuminated by light, nighttime is not aggravating. Number three is observed by treachery. Requisites: the place of facilitate the commissions of or omissions of the crime deliberately soft in not accidental of the commissions of omissions of the crime. Number three is taking advantage of the purpose of impunity. What should be considered here is whether in the place of the commissions of the offense there was a reasonable possibility of the victim receiving some help. 6b. Whenever more than three armed malefactors shall have acted together in the commissions of an offense, it shall be deemed to have been committed by a band. Requisite: if one of four armed malefactors is a principals by inducement, they do not form a band because it is undoubtedly connoted that he had no direct participations. But band is inherent in robbery committed in band in brigandage. It is not considered in the crime of rape. It has been applied in treason in robbery with homicide. Number one is facilitate the commissions of the crime. Number two is deliberately soft. Number three is taking advantage of the purpose of the impunity. Number four is there must be four or more armed men. 7. That the crime be committed on the accusations of conflagrations, shipwreck, earthquake, epidemic, or other calamity or misfortune. Requisites: number one is committed when there is calamity or misfortunes. Number one is conflagrations. Number two is shipwreck. Number three, epidemic. Number two, offender took advantage of the state of confusion or chaotic conditions from such misfortunes. Basis: commissions of the crime adds to the suffering by taking advantage of the misfortunes. Based on time, offender must take advantage of the calamity or misfortunes. Distinction between a paragraph 7 and 12 of Article 14. Committed during a calamity or misfortunes. Crime is committed during any of the calamities. Committed with the use of wastefulness means crime is committed by using fire in additions, explosions, or other wasteful means. Number 8, that the crime is committed with the aid of armed men or persons who ensure or afford impunity. Based on the means and ways requisite, that number 1 is that armed men is or persons took part in the commissions of the crime directly or indirectly. Number 2, that the accused availed himself of their aid or relied upon them when the crime was committed. Exception: when both the attacking parties and the parties attacked were equally armed. Number 2, not present when the accused as well as those who cooperated with him in the commissions of the crime acted under the same plan and for the same purpose. Number 3, casual presence or when the offender did not avail himself of any of their aid or did not knowingly count upon their assistance in the commissions of the crime. With the aid of armed men, presence even if one of the offenders merely relied on their aid, actual aid is not necessary. By a band, requisite more than 3 armed malefactors who all act together in the commission of offense. If there are more than 3 armed men, aid of armed men is absorted in the employment of a band. Number 9, that accused is a recidivist. Recidivist, one of at the time of his trial for one crime shall have been previously convicted by a final judgment of another crime embraced in the same title of RPC, Revised Penal Code. Basis greater perversity of the offender as shown by the inclinations to commit crimes. Requisites. Number 1 is offender is on a trial for an offense. Number 2, he was previously convicted by the final judgment of another crime. Number 3, that the first and the second offense are embraced in the same title of the RPC. Number 4, the offender is convicted of the new offense. Recidivist must be taken into account no matter how many years have intervened between the first time and second felonies. Pardon does not obliterate the fact that the accused was recidivist, but amnesty extinguishes the penalty and its effects. To prove recidivist, it must be alleged in the information in the attached certified copies of the sentence rendered against the accused. Exceptions: if the accused does not object and when he admits in his confessions in the witness stand. Number 10, that the offender has been previously punished for an offense to which the law attached an equal or greater penalty, or for 2 or more crimes to which it attached a lightly penalty. Reiterations or habituality. It is essential that the offenders be previously punished, that is, he has served sentence. Par 10 speaks of penalty attached to the offense, not the penalty actually imposed. Reiterations. Necessary that the offender shall have served out his sentence of the first sentence. Previous and subsequent offense must not be embraced in the same title of code, not always in aggravating circumstances. Recidivist. Enough that the final judgment has been rendered in the first offense. Same title, always aggravating. Habitual delinquency. When a person within a period of 10 years from the date of his release or last convictions of the crime of serious or less serious physical injuries, robbery, theft, estafa, or falsifications is found guilty of any of said crimes a third time or oftener. Quasi-recidivist. Any person who shall commit a felony after having a conviction with a final judgment before beginning to serve such sentence or while serving the same shall be punished by the maximum period of the penalty prescribed by the law, the new felonies. Number 4, form of repetitions. Number 1 is recidivist, generic. Number 2 is reiterations or habitual, generic. Multiple recidivist or habitual delinquency, extraordinary, aggravating. Number 4 is quasi-recidivist, special, aggravating. 11, that the crime has been committed in consideration of a price rewards promise. Requisite at least 2 principles. Number 1, the principle by inducement. Number 2 is principle by direct participants. Number 3, the price, reward, or promote should be previous to in considerations of the commissions of the criminal act, applicable to the both principles. Number 12, that the crimes be committed by means and fire, poisons, explosion, stranding, abuses, or intentional damage thereto, or derailment of a locomotive, or by use of any other artifice involving the great waste of run. Requisite. The wasteful means were used by the offender to accomplish a criminal purpose. Number 13, that the act be committed with the evident premeditations. Essence of premeditations, the executions of the criminal act must preceded by cool thought and reflections upon the resolutions to carry out the criminal intent during the space of time sufficient to arrive at a calm judgment. Requisite. Number 1 is the time when the offender determined to commit the crime. Number 2, an act of manifestly indicating that the culprit has clung to his determinations. Number 3, a sufficient lapse of time between the determinations and executions to allow him to reflect upon the consequences of his act and to allow his consequence to overcome the resolutions of his will. Conspiracy generally presupposes premeditations. When the victim is different from the intended, premeditations is not aggravating, although it is not necessary that there is a plan to kill a particular person for premeditations to exist. Plan to kill the first two persons one meets a general stacks on a village for as long as it will plan. The premeditations must be based upon external facts and must be evident, not merely suspect, indicating deliberate planning. Evident premeditations is inherent in robbery, adultery, thief, estafa, falsifications, and etc. Number 14, that craft, fraud, or disguise be employed. Craft involves intellectual trickery and cunning on the part of the accused. It is employed as the same in the executions of the crime. Accused pretending to be members of the constabulary, accused in order to perpetrate rape, used chocolates contain drugs. Fraud involves an insidious words or machinations used in induce a victim to act manners which would enable the offender to carry out his design. As distinguished from the craft which involves acts done in order not to arouse the suspicions of the victim, fraud involves a direct inducement due entrapping or beguiling the language or machinations. Disguise resulting to any device to conceal identity. Purpose of the concealing identity is most distinctions between craft, fraud, and disguise. Craft involves the use of intellectual trickery and cunning to arouse suspicious of the victims. Fraud involves the use of direct inducement by insidious words or machinations. Disguise involves the use of device to conceal identity. Requisite. The offender must have actually taken advantage of a craft, fraud, or disguise to facilitate the commission of the crime. Inherent in estafa and falsifications. Number 15. That advantage be taken of superior strength or means be employed to weaken the defense. To purposely use excessive force out the proportions to the means of defense available to the person's attack. Requisites of means to weaken defense. Means were purposely sought to weaken the defense of the victim to resist the assault. The means of use must not totally eliminate a possible defense of the victim, otherwise it will fall under the treachery. To weaken the defense, illustrated in the case where the one struggle with another suddenly throws a cloak over the head of his opponent, and while in the said situations he wounds or kills him. Other means of weakening the defense will be intoxications or disabling through the sense casting dirt of sand upon another eyes. Superiority may rise from aggressors, sex weapons, or number as compared to that of the victims. Accused attacked an unarmed girl with a knife. 3 men stabbed to death the female victim. Number 2, no advantage of superior strength when one of attacks is overcome with the passions in obfuscations, or when quarrel arose that unexpectedly in the fatal blows was struck while the victim and the accused were struggling. Number 3 is versus by a band circumstances of abuse of superior strength. What is taken into account is not the number of aggressors, nor the fact that they are armed, but their relative physical might vis-a-vis the offended party. 16. That the act of be committed with the treachery aliviosia. Treachery when the offender commits any of the crimes against the person's employments, methods, or forms in the executions thereof which tend directly and especially to ensure its execution without risk to himself arising from the defense which the offended party might make. Requisites. Number 1 is that at the time of the attack, the victim was not in a position to defend himself. Number 2, that the offenders consciously adopt the particular means, method, or form of attack employed by him. Treachery can't be considered when there is no advantage uh, or evidence that the accused or prior to the moment of the killing resolved to commit to crime, or there is no proof that the death of the victim was the result of meditations, calculations, or reflections. Examples: victims asleep, half awake, or just awakened. Victim grappling or being held attacks from behind. But treachery may exist even if attack is face to face as long as the victim was not given any chance to prepare defense. Does not exist if the accused give the deceased chance to prepare, or there was a warning given, or that it may preceded by a hatred argument. Number 1. Number 2, there is always treachery in the killing of child. Number 3 is generally characterized by the deliberate and sudden and unexpected attack of the victim from behind without any warning and without giving the victims an opportunity to defend himself. Treachery means method or forms are employed by the offenders to make it impossible or hard for the offended party to put an sort of resistance. Abuse of superior strength. Offender does not employ means, methods, or forms of attack. He only takes advantage of his superior strength. Means employed to a wicked defense. Means are employed, but it only materially weakens the resisting power of the offended party. Where there is conspiracy, treachery is considered against all the offenders. Treachery absorbs abuse of strength, aid of armed men by a band, and means to weaken the defense. Number 10, that the means be employed or circumstances brought about the which add ignominy to the natural effects of the act. Ignominy is a circumstance pertaining to the moral order which add disgrace in a oblique way to the material injury caused by the crime. Applicable to crimes against chastity, rape included, less serious physical injuries like grave coercion, and murder. There's a requisite. Number 1 is crime must be against chastity, less serious physical injuries, light or grave coercions, and murders. Number 2, the circumstances made the crime more humiliating and shameful for the victims. Examples: accused embraced and kissed the offended party not out of lust but out of anger in front of many people, raped in the front of the husband, raped in successively by 5 men, tend to make the effects of the crime more humiliating. Ignominy not present where the victim was already dead when such act are committed against his body or the persons. Number 18, that the crimes be committed after the unlawfully entry. Unlawfully entry when the entrance is effected by a way not intended for the purpose meant to effect entrance and not exit. While aggravating of one who acts not respecting the walls erected by means to guard their property and provide for their personal safety shows greater pervasivity, a greater audacity, and hence the law punish him with more severity. Examples: rapist against entrance through the window, inherent in trespass, the dwelling robbery with the force upon things, and robbery with the violence and intimidations against persons. Number 19, that as a means to make commissions of the crime, a wall, roof, door, or window be broken. Requisite number 1, a wall, roof, window, or door was broken. Number 2, they were broken to effect entrance. Applicable only if such acts were done by the offender to effect entrance. Breaking is lawful in the following instances. Number 1, an officer in order to make an arrest may break open a door or windows of any building in which the persons to be arrested is reasonable believed to be. Number 2 is an officer if refused admittance may break open any door or windows to execute the search warrant or liberate himself. Number 3, T. Number 20, that the crimes be committed with the aid of persons under the 15 years of age or by means of motor vehicle, airships, or other similar means. Reasons for number 1 is to repress so far as possible the frequent practice resorted by the professional criminals to avail themselves of minors taking advantage of their responsibility. Reminders that minors are given leniency when they commit a crime. Example, one instructed a 14 years old to climb up the fence and open the gate for him so that he may rob the house. Reasons for number 2, to counteract the great facilities found by modern criminals instead means to commit crime and flee and abscond once the same is committed. Necessary that the motor vehicle be an important tool to consummations of the crime. Bicycles not included. Examples: one in Pedro in committing thief used a truck to haul the appliances from the mansions. Number 21, that the wrong done in the commissions of the crime be deliberately augmented by causing other wrong not necessary for its commissions. Cruelty, when the culprit enjoys in delight in making his victim suffer slowly and gradually, causing him unnecessary physical pain in the consummations of the criminal act. Cruelty cannot be presumed nor merely inferred from the body of the deceased, has to be proven. Number 1 is merely plurality of words do not show cruelty. Number 2, cruelty when the other wrong was done after the victim was dead. Requisites. Number 1, that the injury caused be deliberately increased by causing other wrongs. Number 2, that the other wrongs be unnecessary for the executions of the purpose of the offenders. Ignominy, moral suffering subjected to the humiliations, cruelty, physical suffering. In summary, aggravating circumstances are those which serve to have the penalty impose its maximum period of change of the natures of the crime, while the mitigating circumstances are those which is present in the commissions of the crimes do not entirely free the actors from a criminal liability but serve only to reduce the penalty. Aggravating circumstances are based on the greater pervasivity of the offender, while mitigating circumstances are based on the diminutions of freedom of actions, intelligence, or intent, or on the lesser pervasivity of the offenders. Kinds of aggravating and circumstances ordinarily or generic, those which are applied to all crimes; specific or special, those which applies only to specific crimes; qualifying, those that change the natures of the crime. Uh, Inherent, which of the necessity accompany the commissions of the crimes, therefore not considered in the increasing the penalty to impose a special those which arise under the special conditions to increase the penalty of the offense and cannot be offset by mitigating circumstances. Generic circumstances effect generic when not set off by any mitigating circumstances, it increase the impossible penalty to maximum but without exceeding the limit prescribed by the law. Qualifying gives the crime its proper and exclusive name and place the perpetrator in such a situations as the deserves no other penalty than that especially prescribed by the law for said crimes. Generic, if not alleged informations qualifying circumstances will be considered the generic qualifyings to be considered. As such, it must be alleged in the information's generic circumstances may be offset by mitigating qualifying cannot be offset by mitigating circumstances. Roles in roles on aggravating circumstances. Number one is aggravating. Circumstances shall not be uh, appreciated if they constitute the crime, especially punishable by law or it is included by the law in defining a crime with a penalty prescribed and therefore shall not be taken into account for the purpose of increasing the penalty. uh, Inherent example that the crime be committed by means of fire explosions is in itself a crime of arson on article 321 or a crime involving destructions of article 324. It is not be considered to increase the penalty for the crime of arsons or, or the for the crimes involving destructions. The same rule shall apply with respects to any aggravating circumstances inherent in the crime to such a degree that it must of necessity accompany of the commissions thereof. Uh, Aggravating circumstances which arise from the moral attributes of the uh, offender from his private relations with the offended uh, or from any personal cause shall only serve to aggravate the liability of the principals, uh, accomplices, and accessories as to know whom such circumstance and attendant. uh, the circumstances which consist uh, in the material executions of the act or in the means employed to accomplish it shall serve to aggravate the liability of only those persons who had knowledge of them at the time of the executions of the act or their cooperations therein, except when there is a proof of conspiracy, in which case the act of one is deemed to be the act of all, regardless of the lack of knowledge of the facts of constituting the circumstances. Aggravating circumstances, regardless of kind of, should be especially alleged in the informations in approved at fully as the crime itself in order to increase the penalty in section 9 rule of 110 of 2000 rules of criminal procedure. 6. When there is more than one qualifying aggravating circumstances present, one of them will be appreciated as a qualifying aggravating while the others will be considered as a general aggravating. Article 15. Alternative circumstances. Alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime. In the other conditions attending its commissions, they are the relationship intoxications in the degree of instructions and indications of the offender. The alternative circumstances of relation shall be taken into considerations when the offended party in the spouse, ascendant, descendants, legitimate, natural, or adopted, brother or sisters, or relative by affinity in the same degrees of the offender. The intoxications of the offender shall be taken into consideration as a mitigating of circumstances when the offender has committed a felony in a state of intoxications if the same is not habitual or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstances. Alternative circumstances, those which must be taken into consideration as aggravating or mitigating, according to the nature and effects of the crime and the other conditions attending its commissions. They are: number one is relationship taken into considerations when offended party is the spouse, ascendant, descendant, legitimate, natural, or adopted, brother or sister, or relative by affinity in the same degrees of the offender. Number two is intoxications, mitigating when the offender has committed a felony in the state of intoxication, if the same is not habitual or subsequent to the plan to commit the said felony aggravating of habitual or intentional. Number three is degree of instructions and educations of the offenders. Relationship, mitigating circumstances. In a crimes against property, robbery, absorption, fraudulent, insolvency, arson, aggravating circumstances. In crimes against person, in case where the offender or when the offender and the offended party are relatives of the same level as killing a brother, adopted brother, or half brother. Always aggravating in crimes against chastity. Exceptions: Article 332 of CC. No criminal liability, civil liability only for the crimes of theft, swindling, or malicious mischief committed or caused mutually by spouses, ascendants, descendants, or relatives by affinity. Also brothers, sisters, brothers-in-law, or sisters-in-law if living together. It becomes an exempting circumstances. Relationship neither mitigating nor aggravating when relationship is an element of the offense. Example is parricide, adultery, concubinage. In intoxications, mitigating circumstances: A. If intoxication is not habitual. If intoxication is not subsequent to the plan to commit a felony. Aggravating circumstances: if intoxication is habitual, such habit must be actual and confirmed. If its intention subsequent to the plan to commit a felony. Must show that he has taken such quantity so as to blur his reasons and deprive him a certain degree of control. A habitual drunkard is given to inebriety or excessive use of intoxication drinks. Habitual drunkenness must be shown to be an actual and confirmed habit of the offender, but not necessarily of daily occurrence. Degree of instruction and educations. Mitigating circumstances, low degree of instructions, educations, or the lack of it, because he does not fully realize the consequences of the criminal act, not just mere illiteracy, but lack of intelligence. Aggravating circumstances, high degree of instructions and indications, offender avails himself of his learning in committing the offense. Determined by the court must consider the circumstance of lack of instructions. Exception not mitigating, crimes against property, crimes against chastity, rape include crimes of treason. In a summary of Article 15, discuss the alternative circumstances that can be considered either as aggravating or mitigating factors in a criminal case, depending on the natures and effects of the crime. In other conditions, these circumstances include number one is relationship. This taken into account when the victim is a close relative, spouse, ascendants, descendants, siblings, or relative by affinity in the same degree of the offenders. Number two is intoxications. This is considered mitigating circumstances if the offenders committed the crime while intoxicated, provide the intoxication is not habitual or wasn't part of the plan to commit the crime. However, if this offender's intoxication is habitual or intentional, it's considered an aggravating circumstances. Number three is degree of instructions and indications. The offender's level of educations in instructions is also considered as an alternative circumstances, though the text does not specify how this is applied. And thank you for watching, and I hope you understand my reading of Article 15 and 14 of Criminal Law Book 1. Thank you for listening, and goodbye.